So good day everyone. I am Arbe Novicio and we are from Group 3. So today we will be making a presentation video about the Philippine probation rules and supervision. So in this topic we're gonna tackle about the significant ideas, characteristics, benefits of probation, and when you say it, rules and supervision, what are those or what are the listed rules and supervision of the Philippine probation system in the Philippines?
So before we start our presentation, let's define first what is probation. So according to Presidential Decree number 968, probation is a disposition under which a defendant, after conviction and sentence, is released subject to conditions imposed by the court and to the supervision of probation officer. So meaning, if you are a certain individual who was convicted of a certain crime, and if the court granted you a probation, so there will be a conditions like uh, rehabilitation, therapy, regular drug testing, maintaining a job, and most importantly is reporting to a probation officer. So the purpose of this is that you will given another chance to come back to the society and do something useful in order to avoid criminal behavior. And since you are given a temporary freedom, if you are failure to comply with probation condition, this can result in another prison sentence. So this is Matthew Davenport Hill. He was born in August 6, 1792. He died in June 7, 1872. So he is a British lawyer and penologist, many of whose suggested reforms in the treatment of criminals were enacted into law in England. So also, since he was a lawyer, he is also an advocator, and he promote prison reform campaign. He believed that every offenders is uh, can be given a chance to change themselves back to their former selves. So this is John Agustus, considered the father of probation. He was recognized as the first true probation officers. So Augustus was born in Woburn, Massachusetts in 1785. By 1829, he was a permanent resident of Boston and the owner of a successful boot-making business. So John Augustus was, because of his pioneering efforts to campaign for more lenient sentences, this was created for those convicted person that should be given more lenient sentences based on their criminal background. So meaning, if you have a rough or violent childhood and you experience a psychological traumas or psychological manifestation that force you to do violent and heinous act, you will be given a certain provision like therapy, other government program to help yourself to become or to be back to your former selves.
So these are the six significant ideas and characteristics of probation. So you should take note that this is just like the good effects or the good sides of having a probation system in the Philippines. So first is a more enlightenment and humane correctional system. So since our government and the father of the probation is promoting that every individual should have or given a lenient sentences, especially on those based on their backgrounds. So the government is trying to make that the probation system in the Philippines are inhumane and it's not cruel. Second is to promote the reformation of offenders. Third is reduction of the incidence of recidivism. Fourth is extending to offenders, individualized and community-based treatment programs instead of imprisoning them. Fifth is limited to offenders who are likely to respond thereto favorably. 6 is the method is less costly than confinement. So the purpose of this is that the father of probation and the probation system that the government in the Philippines created is to promote that each convicted person should be treated accordingly. So there are people who were able to commit crimes because of their psychological well-being, being mentally unstable, because of there are many factors to consider. So so the next is benefits of probation. So the benefits of probation is that first and foremost is to protect the society. Second, uh, second is probation protects the victim. So here are the lists: provides restitution, preserves justice. C is probation protects the family. It does not deprive the wife and children of husband and father. It maintains the unity of home. So these are the what we call this good good benefits of having a probation or provisional system. It's then probation helps the offenders. Yeah, probation justifies the philosophy of men. So in this benefits, so it has different specific benefits that it is very important to we should take note in order for us to understand way more deeper than hearing the word probation.
Probation is a disposition under which a defendant, after conviction and sentence, is released or subject to conditions being imposed by the court. And of course, with the proper supervision of a probation officer. So probation can be granted only once, meaning an offender can only apply it once in a lifetime. Let's proceed to the rules on probation. There are many different rules that can apply to an offender's probation, and these are known as conditions of probation. So the following are the potential conditions of probation, such as the offender cannot commit any other crimes while on probation. The offender will attend a work rehabilitation program. The offender will attend a drug or alcohol rehabilitation program if necessary. The offender will obtain a gainful employment. The offender will avoid contact with other criminals. The offender will provide support to dependents. The offender will provide a DNA sample. The offender will register as a sex offender if their crime was a sex crime. The offender will undergo a medical and psychiatric treatment if necessary. The offender will avoid excessive use of alcohol, drugs, or controlled substances, and they will submit to drug testing. Next, the offender will routinely report to a probation officer. Next, the offender will reside in a certain geographic location. The offender will comply with court orders. Next, regularly meeting with your probation officer. Next, appearing at any scheduled court appearances, paying fines or restitutions to the victims, avoid certain people and places, not traveling out of state without the permission or approval of the probation officer, obeying all laws including minor laws like jaywalking, refraining from illegal drug use or excessive alcohol use, and lastly, submitting to drug or alcohol testing. So, it is important to note that this is just an illustrative list, meaning the court is free to impose as many legally proper conditions as necessary.
Application for probation. The application for probation shall be filed by a sentenced or convicted offender whose sentence is not more than 6 years of imprisonment, and it shall be filed with the court that tried and sentenced the offender. When can a petitioner file his application for probation? The law says that the application should be made within the period of perfecting an appeal or within the 15 days from the promulgation of notice of judgment. Where can we file the application for probation? The application for probation shall be filed directly to the trial court that heard and sentenced the person applying for probation.
What then be the duty of the court after receipt of the application? So, the trial court may notify the concerned prosecuting officer of the application at a reasonable time before the schedule of a hearing. What are the rules in applying for probation? So first, the offender or his counsel files a petition with the convicting in a court. Second, the court determines the convict qualification and notifies the prosecutor of the filing of the petition. Third, the prosecutor submits his comments on such application within 10 days from a receipt of a notification. Fourth, if the petitioner is qualified, his application or is referred to the probation officer for a post-sentence of investigation. Fifth, the post-sentence investigation report or PSIR is submitted by the probation officer to the court within 60 days. Lastly, the court grants or denies the petition for probation within 15 days upon receipt of the PSIR. How long is the period of the probation? So, not more than 2 years if the sentence of the offender is 1 year or the less than, and not more than 6 years if the sentence is a more than 1 year.
What are the effects filing an application for probation? The court may, upon receipt of the application, suspend the execution of sentence imposed in the judgment. Ang korte ay may kakayahang suspindihin ang pagbigay ng asistensya sa isang nahatulan ng isang krimen. Second, pending the submission of PSIR and the resolution on the application, the applicant may be allowed on temporary liberty under his bail, on a new bail, or release on recognizance. Habang ang pre-sentence investigation report ay nasa diskusyon, ang aplikante ay bibigyan ng kalayaan pansamantala habang nasa proseso pa ang kanyang pag-apply ng provision. When provision is granted, what conditions are imposed by the court? First, the provisioner must present himself to his probation officer within 72 hours. Kailangan magpakita ka sa iyong probation officer upang mabigyan ka ng guidance sa loob ng 3 araw. Report to his probation officer at least once a month. Kailangan mo magpakita kahit isang araw sa isang buwan upang mabigyan ka ng supervision. Third, not to commit another crime. Kailangan hindi ka dapat gumawa ng isang krimen para hindi masayang ang iyong probation at hindi ka makulong ulit. Fourth, comply with any other lawful condition imposed by the court. Kailangan mo sundin lahat ng utos galing sa korte para iwas problema.
So, our topic is all about if the probationer commit a crime while under probation, what would be the consequences? So, first, the probationer will be arrested for the violation of the condition of probation. Second, the prosecution of the new crime committed. Then third is the court will order the serving of the original sentence to the previous offense. So first is he will be arrested, second new crime committed, then third serving the original sentence of the previous offense. Next, what are the rule on outside travelers? So the rule is probation officer authorized the probationer to travel outside the area of the operation for a period of 10 days but not exceeding 30 days. So what if it exceeds 30 days or it is 30 days? So if 30 days, probation must file 5 days before travel request to travel outside to approve the probation authorities. So it is also discussed here that if it is more than 30 days. So in more than 30 days, probation authority shall be recommend for the court approval. So the court will be approved if it exceeds 30 days. Then what are the rules on charges of residence? So the probationer must file a request for a charge of residence at the city provincial parole and probation office to the court to be approved. Then if approved, the RTC will has jurisdiction over the place shall have the full control of the probationer. So the RTC will be charged of the full control of the probationer. Lastly, the court will not grant probation if it is finds that the offender can be treated better in mental institution or other place for correction. Then the offender is at risk to the community also. Then lastly, if the offender is grievous to the eye of the community, then the court will not grant probation if it is finds mental institution to the other place of correction, risk to the community, grievous in eyes of the community.
Who cannot be granted probation? First, sentenced to serve a prison term of more than 6 years. You cannot be granted probation if your term of imprisonment is more than 6 years. Second, convicted of any crimes against national security or the public order. When we say crimes against national security, those are sabotage, espionage, treason, and crimes against public order. Those crimes are rebellion, sedition. The person cannot be granted probation if he or she committed those crimes. Third, previously convicted of an offense which is punished by imprisonment of more than 30 days and or a fine of 200 pesos or more. Fourth, who have once been placed on probation under this law. Once you have been granted probation and you repeat the same crime, you are not allowed to apply again for probation because it will only be given once. Fifth, already serving sentence at the time the substantive provisions of this decree became applicable pursuant to Section 33. Sixth, sentenced to a probationable penalty but appealed the same. Seventh, convicted of an offense against the Omnibus Election Code and wage regionalization. And lastly, convicted of illicit trafficking or pushing of dangerous act. What conditions are imposed by the court on an offender who is released on probation? First, to report to the probation officer within 72 hours after receiving the order of the court granting probation. It is required by the court that you present yourself and report to the probation officer. Second, to report to the probation officer at least once a month. Third, not commit any offense or violation while on probation. Fourth, comply with any other condition imposed by the court.
Probation agencies provide supervision of offenders in the community. After an offender has been granted probation, a probation officer, hereafter referred to as PO, is expected to supervise that offender in the community. The basic question remains, what is the purpose of supervision? The purpose of supervision are the following. A. To ensure the probationer's compliance with the probation conditions specified in the probation order and the prescribed probation treatment and supervision program plan. B. To manage the process of the probationer's rehabilitation and reintegration into the community. And C. To provide guidance for the probationer's transformation and development into a useful citizen for his eventual reintegration to the mainstream of society, contract with others, who have successfully conquered their problems. Thus, providing treatment is only one aspect of supervision. In addition, the PO is expected to maintain surveillance of those offenders who make up the caseload. A classic definition of surveillance was provided by the National Conference of Parole. Surveillance is that activity of the officer which utilizes watchfulness, tracking, and verification of certain behavior of a probationer. Many believe that the PO has two major responsibilities: to rehabilitate the offenders who are amenable to treatment, while simultaneously protecting society from those who prove to be dangerous. Supervision of offenders usually involves both surveillance of offenders and assistance that will help the offender remain crime-free in the community.
So what is required? So when you under supervision, so the probation officer will put together a supervision plan with you, and you will obligate to attend regular scheduled meetings with them. So the probation officers will help you to find out what are the root causes of your offending are. So they help you to build motivation to make positive changes and help to develop ways to avoid falling back into the same pattern of behavior. So they will also monitor that you are doing your part and complying with the terms of your recognizance. And so the purpose of supervision plan is to give you a roadmap and the tools to help to change your behavior from the path that you are currently on. So when you receive a probation order, you have effectively entered into a contract. So you have promised the court to number one is be a good behavior and not to behave in a way which you undermines the purpose of supervision period. And the second is avoid any further crime. And the third, follow the probation officer's instructions. And lastly, and inform the court of any change of address.
Upon grant of probationer's application for probation by the court, he or she will be placed under probation and will be called as probationer. He or she will undergo supervision under the supervision of probation and will be obliged to comply with mandatory and probation conditions. So in section 35, mandatory conditions, there are two probation orders shall require the probationer. First is to present himself to the probation office for supervision within 72 hours from receipt of the said order. And second, to report the assigned SPPO, Senior PPO, PPO2 or PPO1 on case at least once a month during the period of probation at such time and place as may be specified by the probation office. Section 36. Other conditions. The probation order may also require the probationer in appropriate cases such as A. Cooperate with his program of probation treatment and supervision. B. Meet his family responsibilities. C. Devote himself to a specific employment and not to change said employment without proper written approval of the CPPO. Next, undergo medical or psychological or clinical or drug or psychiatric examinations and treatment and remain in a specified institution when required for that purpose. Comply with the program of payment of civil liability to the offended party or his heirs, when required by the trial court as embodied in its decision or resolution. F. Pursue a prescribed secular study or vocational training. G. Attend or reside in a facility established for instruction, recreation, or residence of person on probation. Next, refrain from visiting houses of ill repute. Next, abstain from drinking intoxicating beverages to excess, and permit the supervising probation officer on case or unauthorized social workers to visit his home and place of work. Next, reside at premises approval by the trial court and not to change his residence without proper written approval of the said court, and or satisfy or any conditions related to his rehabilitation in the useful citizen which is not unduly restrictive of his liberty and incompatible with his freedom of conscience.
Probation supervision process. So first, to carry out the compliance with the terms and condition of probation and to ensure that the reformation is achieved. So the probationer and his or her probation officer will prepare a supervision treatment plan or STP in order to embody the goals and objectives of the rehabilitation program. So the STP or supervision treatment plan will be regularly evaluated by the probation and parole officer for appropriate action and intervention. So second, during supervision period. So if the probationer fails to show up at the office after a reasonable time, then he or she considered an absconding probationer. In effect, to his or her probation may be revoked. So it will be revoked. Then third, non-compliance with probation conditions may result to modification of the probation conditions, or probation officer may file a violation report to the court indicating the victim. So the due process shall be done, and the accused shall be given the chance to be heard. So if the reasons are meritorious, then the probation conditions may retained or we call this a modified if not reasonable. Then the court may be upon its discretion it issue a revocation order. In this regard, the probation will be ordered to serve the original sentence imposed to him and to honorable court. So the fourth is, if probationer has substantially complied with the probation conditions. So then the probation and the parole officer shall recommend the discharge of the petitioner for probation by submitting a final report by retaining or probationer all of his or her civil rights lost by the virtue of the offense committed. So the next part is the probationer shall be monitored accordingly to the following manner of supervision. So there are three manner of supervision. So first is the maximum supervision. So in this supervision, it is a form of supervision wherein clients are required more than twice per month. So it required to report at least more than twice per month. So the second is the medium supervision. It is a form of supervision where clients are required to report at least twice a month. So in this supervision, the clients it should be report at least twice in order to supervise their supervision. Then the last one is the minimum supervision. It is a form of supervision wherein clients classified with the minimum supervision and are required to report to the probation office once a month. So in this supervision, the clients are classified with a supervision are required to report probation officer at least once a month. So that's all. Thank you.
Good day everyone, I am Mary Grace Mingaray and this is the continuation of probation supervision. In Section 39, Commencement of Supervision Service, for purposes of these rules, that the supervision service begin in a day of initial report of probationer, and that is required for a probationer to be under supervised. Section 40, Initial Report. Upon the probationer's appearance for his initial supervision, the supervising probation officer on case, or CPPO, himself shall give instructions to the client using PPA Form Number 4 in order to reinforce probationer's awareness of the probation conditions specified in the probation order in a language or dialect understood by him. Formulate with the client the supervision treatment plan and carry out other related activities. Upon receipt of a copy of PPA Form Number 4 and a copy of the provision order on a particular probationer, the probation office through the CPPO shall immediately assign the probation supervision case to his subordinate probation officer. The probation officer do their part of giving instructions to give awareness of what the conditions will the probationer to comply. Section 41. Outside travel. A probation officer may authorize a probationer to travel outside his area of operational territorial jurisdiction for a period of more than 10 days but not exceeding 30 days. A probationer who seeks to travel for up to 30 days outside the operational jurisdiction of the probation office shall file at least 5 days before the intended travel schedule a request for outside travel with said office, properly recommended by the supervising probation officer on case and approved by the CPPO. If the requested outside travel is for more than 30 days, said request shall be recommended by the CPPO and submitted to the trial court for approval. Outside travel for a cumulative duration for more than 30 days within a period of 6 months shall be considered as a courtesy supervision.
Good day, I am Jon Audrey Patricio, and I will continue the discussion about the Philippine Probation Rules and Supervision according to Section 42, Change of Residence and Transfer of Supervision. The probationer can or may request for change of residence. As a result, the reason must be stated, and furthermore, the request must be submitted by the supervising probation office for the approval of the trial court. In case of approval, the probationer shall be transferred to the concerned executive judge of regional trial court, having jurisdiction and control over said probationer, and lastly, the receiving city or provincial and parole and probation office shall duly furnish each with copies of pertinent probation order. And let's go to the last topic, determination of probation supervision according to Section 60. The probation supervision may be end or terminated in any of the following reasons. First is the successful completion of the probation. Second, the probation revocation for cause under Section 49. Third is the death of the probationer. Fourth is the early termination of the probation. And lastly, the order analogous causes or reason on case-to-case basis as recommended by the probation office and approved by the trial court.
Thanks for watching.